Welcome to News You Can Use in Your Personal and Professional Lives, a production of the Finn Financial Group, all rights reserved. I'm your host. My name is Dan Finn. I am a 20-year plus veteran of the structured settlements industry. My firm exists to help clients achieve maximum financial security through the effective use of structured settlements and other specialty annuity products and services. I want to thank you for giving me the opportunity to be of service to you today. Today's session is entitled Structured Settlements versus Blocked Accounts, Ensuring a Minor's Best Outcome Following an Injury Claim. We designed this exclusively for our valuable clients across the United States who have been asking us a lot of questions about these two options lately. As you view this webinar, please bear in mind the original air date of July 2nd, 2012. Laws can always change, interest rates are always in flux, so it's important that you call to have your own unique situation evaluated prior to making any final decisions. We're going to keep today's outline pretty simple. We're going to begin by comparing and contrasting blocked accounts to structured settlements, including a brief discussion on Kiddie Tax. We're going to help you quantify which is better by making some apples-to-apples comparisons with actual cases so you can decide for yourself which is better. And we're going to end by talking about the due diligence obligations that people have anytime they're involved in a structured settlement or personal injury claim. Making the right choice. Up front, I want to acknowledge that we realize there are some very serious personal injury claims, not just for minors, but all plaintiffs, that involve more complex resolution strategies. Traumatic brain injuries, quadriplegia, paraplegia, severe burns, all of those are beyond the scope of this particular webinar. But the truth is that the vast majority of claims that are filed for minors in the United States are typically resolved and can boil down to some simple math. The claim will settle for X number of dollars, and from that settlement there are usually some upfront costs. These can include attorney fees, liens, advance payments, etc., and the minor is left with a Z settlement sum. It's at this point, Z, where we're going to focus our attention today so that we can help everybody involved in the process make the proper decision to ensure the best recovery possible. Making the right choice. So once we arrive at Z, the minor's net recovery, the court will typically only approve one of two options. The first option is a blocked account. Funds, the net Z is ordered by the court to be taken down to a local bank, a deposit made, and a statement brought back to prove that the deposit was made, and the funds will remain there until the minor reaches the age of majority. The second option is a structured settlement. Structured settlements can also be designed to pay out at age 18, but have a little bit more flexibility and usually, but not always, offer a better rate of return. The questions that everybody involved needs to ask is, which option is better and how can I tell the difference? We're going to help you with that. First, in order to determine which is better, we need to know a little bit about the situations. Not just the minor's age, but other factors enter into the decision before we make a recommendation. All of these factors are important and need to be considered. Most minor settlements are subject to court approval. Now, there are de minimis cases, smaller settlements that can escape and can conclude without court supervision, but the vast majority of claims in the United States require the court's approval. And because the courts have a paternalistic view of their role, rightly so, that they want to make sure that the settlement proceeds are placed only in ultra-safe accounts so that the claimants or the minor's funds are not exposed to risk. If it's not placed in a structured settlement, then this will usually involve just going down to the local bank, making the deposit, proving to the court that you've made the deposit. Once the funds are in place, they are blocked or access is restricted until the age of majority. Age of majority is 18 in most states, some states 19, and some other restrictions may apply. Let's look at the advantages of a blocked account. First advantage is they're very simple. We just described it. You know what the amount is, take it to the bank, prove to the court you made the deposit, and it's done. The second advantage is you can access these funds in an emergency if you need to. That, of course, is subject to court approval. I might stress that the court very often does not approve these requests. I'll tell you a story about that in a little bit. What are the disadvantages of a blocked account? One of the disadvantages is the interest rates that are earned. Banks typically will only offer passbook savings rates here, and any of you that have a savings account today probably knows how much you can expect for that. Bank fees. There are ATM fees that banks charge. There are check writing fees that banks charge. Banks charge fees, it seems, for just about everything. And this has become somewhat of a cash cow for a lot of banks. If they can make as much money on fees as they do on other whatever they're not making on their interest or their deposits, this helps them with their bottom line, but it doesn't necessarily inure to the benefit of the miner. Early access is possible, but does require court approval. Keep in mind here, if you do go to the court, you're going to have costs, legal fees if you have to hire an attorney, and courts will often reject. I told you I'd tell you a story here. I had one where a parent went to the court and petitioned the court to get early access to her son's minor settlement because of his injury. She wasn't getting enough sleep, and she said she needed to get a new waterbed so she could sleep better to take better care of him. The judge, in his infinite wisdom, rejected that request and told her that while he appreciated that she might need to get a good night's sleep and get a bed, he said that she was not going to do it on her son's injury settlement proceeds. A lot of people don't know about Kiddie Tax. Kiddie Tax can apply on larger settlements up until age 24. It's rarely considered, but on large settlements, it can really have an impact. What is Kiddie Tax? Internal Revenue Code Section 1G is available if you really like reading the Internal Revenue Code. But briefly, it was created by the Tax Reform Act of 1986 because Congress learned that several wealthy individuals found a loophole in the tax code that allowed them to reposition some of their earnings, some of their income, to the names of their minor children where they didn't have to pay any, or they could pay very little tax on it. Even though it wasn't the child's money, it was theirs. They were just taking advantage of a tax loophole. Congress closed that door in '86, updated the act several times, updated the Kiddie Tax several times, so that most recently in 2007 they extended the Kiddie Tax through age 23. Once upon a time, the Kiddie Tax was designed only to capture funds up until age 14, but now it goes potentially up to age 24. Parents whose children have income that exceeds a certain threshold are going to be required to complete Form 8615 or 8614 or both, and if they have to pay a CPA to do it, then that's more cost to them. They need to do this to calculate the taxes that are going to be due. The taxes that are due on the first $950 of income is no tax. This is not what Congress was really concerned about. That first $950, that's not a real big deal, but that's not who they were trying to catch with the creation of this section. And this amount, by the way, $950, is tiered. It's $950 here in 2012, I forget what it was originally, but when I first started doing these, it was $700 or so, and usually goes up over time. The second $950 is taxed at 15%, still not too bad of a deal, but the third tax assessed, anything over $1,900, is taxed at the parent's marginal rate. What is the marginal rate? Well, that can be anything. It can be 25%, 30%. I've seen them almost as high as 45% before. The marginal tax bracket is the percentage of tax that's paid on the last dollar earned. And this is to be differentiated from the average tax bracket. Most of us live by the rule of thumb that for every $3 we earn, we usually pay about 1 in taxes. Your marginal tax bracket is always going to be higher than that because you're paying on the last, it's taxed at the rate of the last dollar earned in a progressive tax system. Structured settlements, just like blocked accounts, are also subject to court approval, also need to have the funds tied up in a safe, secure account. So if it's not in a blocked account, that means a structured settlement. Structured settlement is typically a purchased fixed annuity from a life insurance company. These life insurance companies that are in the structured settlements business today are rated A, A+, or A++ by AM Best, an independent rating agency. And insurance is regulated in all 50 states by the insurance commissioners, and there are multiple layers of consumer protections that are in place to make sure that the funds are safe and secure. United States Treasuries are also available for people who are seeking the ultimate in security. Structured settlements are endorsed or used by professionals that are at the top of their game in the personal injury arena. All of these professionals, all of these groups are very familiar with structured settlements and recommend them and use them when they are appropriate for a number of reasons, because they're so good for all the parties involved. What are the advantages of a structured settlement? Structured settlements are also simple. You know what the net amount is, you call a structured settlement person, they take care of the rest. Unlike a blocked account, the income that's earned on structured settlements is 100% income tax free per section 104A2 of the Internal Revenue Code. The rates that structured settlements offer are usually, but not always, better than what banks will offer. And also, unlike blocked accounts, there are no fees or costs involved. A structured settlement is a contractual arrangement that will be paid out on the date specified with no reduction for fees, costs, or taxes. Unlike blocked accounts, you can create different options beyond the age of majority. A blocked account that will pay out at age 18, if the minor wants to, once he reaches age of majority, he or she reaches age of majority, wants to go down to the bank and withdraw all of their settlement proceeds and buy bubblegum with it, there's nothing that the parents or the courts or anybody can do to prevent that. By contrast, a structured settlement will allow the parents and the attorneys to design options that will better meet a post-18-year-old's needs, such as college plans, lump sums at future key milestones, and so on. Usually several choices are presented and the parents will pick the one that's right for them. But for this purposes, we're just comparing age 18 to age 18. And on large settlements, best of all, there are no kiddie taxes. Kiddie taxes can really take a ding out of a larger settlement. We'll show you how dramatic that can be a little bit. What are the disadvantages of a structured settlement? One of the disadvantages is that shorter duration options are totally unworkable. Any money that's needed within the first 3 to 4 years is often better in a blocked account. I've got written here, but don't assume. Again, rates change all the time, and it's possible that by the time you're reading this, watching this at some point in the future, the situation will be different. the question will come up, why is that so? Well, life insurance companies have transactional costs, capital requirements. They're limited and restricted on what they can invest in, so that they can't really find anything that they can invest in that's safe and secure, that's going to return them anything, given the costs and the pricing structure of structured settlements, that they can return anything in the first couple of years. And in these situations, you are better off with your funds in a blocked account most of the time. Emergency liquidity is a little bit more difficult, but not impossible to obtain with a structured settlement. To quantify the difference, the best thing is to call a structured settlement expert. But basically what they should be doing, and you should be doing, is evaluating the blocked account with the structured settlement and comparing. Don't assume, because a lot of bad things can happen when you assume. You think you know something. I'll show you an example here in a minute, and we find out the exact opposite to be true. Look ahead and plan for several years down the road, not just the court approval process. The structured settlement expert will be happy to assist you in this regard. Before we show the specific examples, let's look at let's take a quick review of some of the relevant tax codes. Section 104A2 is the section that says your settlement proceeds are 100% income tax free, whether by lump sum or periodic payments. So that means structured settlement payments are tax free. Internal Revenue Code Section 130 allows for a convenient mechanism to have structured settlement transactions completed. Section 5891 is the section that regulates the selling of structured settlements after they're put into place, and some sections beyond the scope of this particular webinar, 104A1, which has to do with workers' compensation, 468B, which has to do with qualified settlement funds, and there are assorted revenue rulings about structured settlements and about other structured settlement-like products that we get involved with, that we can maybe save those for another day. Okay, let's look at some actual cases. This is actually a true case. I apologize, by the way, up front for this looking a little fuzzy. This is a PDF file that I put on my slideshow. This works best. If you haven't done it already, you might want to change to full screen so you can see it. And if you want, I'd be happy to send you a copy of what this looks like. Just send me a note. I'll shoot you an email so you can look at it a little more clearly without having to put glasses on. This is actually a real case. A client of mine, long-term client of mine, called me and said, I have a claim for a minor, and he's netting about $250,000, but I'm just going to put it into a blocked account because rates are so low. I know structures aren't paying anything. It doesn't make any sense to put it into a structured settlement. So we asked a few questions. He found out that the minor was 10 years old, and for various reasons, the entire net amount was going to be required to be paid out at age 18. So the first thing that I did is I went down to bankrate.com and I looked at the national rates and plugged in the zip code for this particular claimant and determined that even for a jumbo rate, which is $100,000 or more, jumbo rates in this case for this particular bank, the best rate that I could find was 0.84%, and they were lucky to get that. Some of the other banks were offering 0.2%, 0.5%, but 0.84%, not great by historical standards, but certainly better than what a lot of banks are paying today. I then asked some questions about the parents' jobs, what their earnings were, and I looked up their federal, state, and local taxes and determined that their estimated marginal tax bracket was a little over 34%. Next thing I did is I created a spreadsheet here that shows what that 250 might grow to if it was left in for 1, 2, 3, 4, all the way up to 18 years. And as we talked about before, the first 3 years or so, the payouts were actually going to be less than $250,000. So I left those blank. Nobody's going to take a structured settlement if the payout is going to be less, unless it's a taxable situation, but that's another story. But nobody would want this payout for a minor on a personal injury claim that was going to pay less than was put in. By contrast, if you put this $250,000 into a blocked account and it earns 0.84% that first year, it's going to earn a little over $2,100. So we know the Kiddie tax applies. The first tax that is deducted from that $2,100 is 0 on the first $950, $142.50 on the second $950, and the third tax that's assessed is the parent's marginal tax bracket, which is $71.63. That's the amount over the approximate $300 or so, 200 some dollars above $1,900. So not a lot, but still a decent chunk. So at the end of the year, that lump sum is going to be worth a little less than $252,000. That's the first year. We then move this lump sum over to the beginning of the second year, and we do this exercise all the way through until 8 years down the road. We learn that the blocked account, we estimate, is going to pay out approximately $265,000, a little more than that at age 18, compared to a structured settlement which is going to guarantee $293,000. Now that's $28,000 more, almost 10.5% more money that the minor earns with a structured settlement than by simply leaving it into a blocked account, assuming the interest rate there remains constant. That's a pretty significant difference. In this case, the attorney was very glad he called. His clients were very glad that that he called me, and I'm sure that once they get to the court, once they did get to the court actually not through the court yet, but the court's going to be very pleased once they see this and learn that they've done their due diligence and made the comparisons properly. Just for fun, I wanted to see what would happen if we take out the Kiddie tax altogether. Let's just say, or not altogether, but just mostly, and say the parents don't have any marginal tax bracket. Pretty unlikely scenario, but let's just say that's the case. They have no taxes. $250 earns $2,100, still no tax here, still $142, so they take a little bit of tax away. But still, at the end of 8 years, even without the Kiddie tax, the minor still comes out better with a structured settlement. They come out 10.18% ahead versus if they leave it into a blocked account. What if you don't have $250,000 and you're only working with $50,000 in your net recovery, the Z amount of money? And let's just assume for the time being that you can still get 0.84%, and the parent's marginal tax bracket is still somewhere in the 34% range. In this case, you can see that the interest that's earned never reaches $950, so there's no tax anywhere here. So the Kiddie tax is a total non-issue in this particular situation. Smaller lump sum, but even despite that, 8 years down the road, the minor still comes out ahead with a structured settlement because the minor will earn approximately $5,000 more by placing it into a structured settlement than he would if it was in a blocked account. That's about 9%, 9.25% more money. Not to mention what would happen if this was a baby we were dealing with. He or she would even have a significantly larger difference if this was a baby that we were talking about. What if we were using $1 million, ignoring the fact that you wouldn't want to put $1 million in any single bank account, probably split this up amongst a couple, but let's just say for the sake of argument you could still put them all together, get 0.84%, and the marginal tax bracket was 34.7. $1 million deposited, $8,400 in interest that's earned. 0 Kiddie tax on the first $950, $142.50 on the next. And this is what the Kiddie tax was really designed to go after, is minors, not minor settlements, but parents that were shifting these large lump sums into their kids' names. The tax that's paid on this because of their marginal tax bracket is pretty substantial, $2,200. So that out of that $8,400 in interest that's earned, the minor is only going to be left with a little over $6,000 by the end of that first year. Still better than a structured settlement, unfortunately. But after the fourth year, you can see it becomes pretty much a break-even proposition. But 8 years down the road for this minor, the blocked account is going to pay $1,050,000 approximately, compared to a structured settlement, which is going to pay $1.174 thousand, $125,000 difference in tax-free money that the structured settlement pays versus what a blocked account would pay. That's almost 12% more money, and I don't know anybody that would want to voluntarily deny their child the opportunity to have that much more money at the age of 18. And again, we're ignoring the fact that this funds are available at age 18. Probably a lot of temptations for that minor, assuming he's competent and everything at age of majority. But normally we'd spread this out over a couple years. So all of those aside, even on an apples-to-apples basis, the structure is better. At this point in the presentation, a lot of people might say, yes, but if I have the funds in a blocked account, at least my child's going to benefit when interest rates go up. And I'm positive interest rates are going to go up. They're going to shoot through the roof so fast, so quickly, that I would be denying my child an opportunity to earn that money if I simply lock into a structured settlement. And my response to that would be, not so fast. Let's take a look at what history says. If I go back 135 years plus and I look at every time interest rates have been below 4% for longer than a year and ask how long did they remain depressed below 4%, the answer is kind of surprising. The first scenario, they were below 4% for 31 years. Second time that happened, 35 years. This is the Great Depression, and you can see these 30 years or so following the Great Depression, the interest rates never really did a whole lot. Third period of time began a couple years ago. So if this is true, and this is true, and this period of time is anything like the first two, history suggests we're going to be in for a pretty prolonged period of low interest rates. I know a lot of people do not want to hear that, and the truth is nobody knows what's going to happen. We could end the year here. We could end the year here. We could end the year here. It's the only thing we know for sure is that nobody knows what's going to happen. But as I look at things, and the economists that I listen to and respect and have heard speak and have read, I think bear this out, that yeah, we might be lower than we've ever been in a long time, and we probably will go up. Some are saying 2014, but I don't think there's any reason to believe that we're going to go up dramatically. So even if interest rates do rise a little bit, I believe that structured settlements will still leave the individual in a better place. In closing, I just want to talk about why it's critical to have your own expert involved. First off, it's your right to have your own structured settlement person involved to help you evaluate things. Structured settlements are voluntary three-way agreements, and you want to make sure that the person that's looking over your shoulder has done everything right. Generally, there's not a requirement to structure anything. Sometimes there is a requirement to structure, but for the most part, structured settlements are voluntary choices that are made during the settlement negotiation process. Good one, I might add, and appropriate for many situations, but not every situation. Accountability, you want somebody that will know what they're doing for your documents. You can count on them to maintain confidentiality. And also prevents unintended consequences. I had a client one time who told me that the claimant, the unrepresented claimant, mother was just going to take the funds and put them into a bank account. Well, what she ended up doing was going to a very inexperienced financial planner who recommended, with a pretty moderately sized settlement recovery, that the minor set it aside for a retirement annuity that was going to begin paying at age 65. Not only was that totally inappropriate for that particular individual with special needs, the court would have never approved such a thing. You have your own expert, otherwise you're at the risk of the other expert becoming your agent. And if you are new to the structured settlements business, it's important to understand that there's no charge for our services ever. We get paid if and when, and only if and when, the structured settlement is put into place and if it's a beneficial option for the person and the client that we're dealing with. If it doesn't work and a structured settlement's not involved, you don't get a bill from us. If a structured settlement does work, you still don't get a bill from us. We get paid by the life insurance company. And for some additional reading, I would direct you to our website, where we have an e-guide that we put together, Structured Settlements Offering What the Economy Can't, where we seek to debunk several common myths surrounding the structured settlements industry today. And while you're there, you might want to sign up for our e-newsletter and blog to keep abreast of important topics of interest. If you have any questions about today's session, please feel free to write, call, or email. I'd love to hear from you. Let me know what you think and how I can help. And that will conclude today's sessions on structured settlements versus blocked accounts. I want to thank you all for taking the time to check in today. I appreciate the opportunity to be of service. I wish you all the best in your personal and professional lives going forward, and hope we'll have the opportunity to talk someday soon. Thank you very much.